we have to understand what does section 168A stand for. Notwithstanding anything contained in this act, the government may, on the recommendation of the council, very, very important phrase. My dear friends, before the High Court, it was argued that the show cause notice was issued on 31/5/2024. Several High Court decisions were cited to support their argument. Barkataki Print and Media Services versus Union of India. The Guwahati High Court opined that the recommendation of GST Council on the recommendation of the Council is to equip the government with the expert opinion of the expert constitutional body, that is the GST Council. Supreme Court on GST. My dear friends, can time limit to adjudicate show cause notice be extended by notification under section 168A is the question of law which has been asked now before the Apex Court. My dear friends, before we understand this question, we have to understand what does section 168A stand for. If you see, my dear friends, in the GST Bar Act, if you refer to section 168A, it says power of government to extend time limit in special circumstances. There is a provision provided under section 168A wherein the government has the power to extend the time limit in certain situations. What are those situations? My dear friends, section 168A subsection 1 provides for the same. My dear friends, this section was inserted by the Taxation and Other Laws, Relaxation and Amendment of Certain Provisions Act 2020, 38 of 2020, that is on 29/9/2020 with effect from 31/3/2020, that is during the COVID time. My dear friends, section 168A subsection 1, I read the exact words of the provision. It says, it starts with non-obstante clause actually. My dear friends, it says, notwithstanding anything contained in this act, the government may, on the recommendation of the council, by notification, extend the time limit specified in or prescribed or notified under this act in respect of actions which cannot be completed or complied with due to force majeure. Section 168A subsection 2 provides for the power to issue notification under subsection 1 shall include the power to give retrospective effect to such notification from a date not earlier than the date of commencement of this act. My dear friends, the explanation to section 168A, for the purpose of this section, the expression force majeure, case of war, epidemic, flood, drought, fire, cyclone, earthquake or any other calamity caused by nature or otherwise affecting the implementation of any of the provisions of this act. My dear friends, this is a power of the government in special circumstances brought during the COVID period. Here is a petition before the Supreme Court. This petition is filed in case of Mrs. HCC SEW MEIL AAG JB versus Assistant Commissioner of State Tax and others. A petition for special leave to appeal number 4240/2025. My dear friends, under this case, it is very important to note that the Supreme Court is to decide whether the time limit for adjudicating show cause notice and passing an order can be extended. My dear friends, whether it can be extended by the issuance of notification under section 168A of the GST Act. This provision empowers the government to issue notification for extending the time limit prescribed under the Act which cannot be complied with due to force majeure. My dear friends, the bench clearly observed, I quote the exact words of the bench. The Supreme Court bench said, the issue that falls for the consideration of this court is whether the time limit for adjudication of show cause notice and passing an order under section 73 of this GST Act. My dear friends, it's very important to understand what is section 73. My dear friends, section 73 provides for determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized for any reason other than fraud or any willful misstatement or suppression of facts. My dear friends, under section 73, it is a case of other than fraud or any willful misstatement or suppression of facts. My dear friends, it is pertinent to refer to section 168 subsection 1 one more time. It reads as section 168A, power of government to extend time limit in special circumstances. Under that subsection 1, Notwithstanding anything contained in this act, the government may, on the recommendation of the council, very, very important phrase, on the recommendation of the council, by notification, comma, extend the time limit specified in, comma, or prescribed or notified under this act in respect of actions which cannot be completed or of complied with due to force majeure. My dear friends, initially the batch of petitions challenging this position of law was filed before Telangana High Court in its writ jurisdiction. Therein, among others, they had challenged the legality, comma, validity and proprietary of notification number 13/2022. My dear friends, dated 5/7/2022, 56/2023, dated 13/3/2023 and 28/12/2023 respectively. My dear friends, before the High Court, it was argued that the show cause notice was issued on 31/5/2024. However, an order was passed on 29/8/2024 after the maximum period of limitation as given under section 73 of the Act. My dear friends, the petitioners submitted that no force majeure conditions existed. Thus, in absence of such condition, no notification could have been passed. Apart from this, they contended that even the COVID-19 relaxation extensions are not available as the same lasted till 28/2/2022. My dear friends, several High Court decisions, in case of the similar matter, several High Court decisions were cited to support their argument. The case that they referred was Graziano Transmissions versus Goods and Service Tax. The Allahabad High Court inter alia opined that the orders of the Supreme Court in suo motu jurisdiction relaxing limitations are inapplicable for proceedings under the GST Act. My dear friends, while placing reliance on this judgment, the petitioner also highlighted that the court noted that impugned notification was issued pursuant to the decision of the GST Implementation Committee and not by the GST Council. However, it failed to address the difference between recommendation of committee and ratification by council. Very important point, my dear friends. The point of law that is traveling today in Supreme Court is that recommendation of committee and ratification by council. My dear friends, Bargataki Print and Media Services versus Union of India, the Guwahati High Court opined that the recommendation of GST Council sine qua non for exercising power under section 168A of the Act. Sine qua non means something which is indispensable for exercising power under section 168A of the Act. My dear friends, in the present case, on the issue of recommendation and ratification, the High Court observed that the recommendation of the Council leaves no room as a condition precedent before the government issues the notification. It pointed out that the notification number 56/23 was issued without there being any recommendation of the Council. The same was passed based on the Implementation Committee decision. This ratification done after issuance of notification under section 56/2023 will not provide life to notification number 56/2023, it added and reasoned. My dear friends, the observation was, I quote the exact words, the purpose behind using the phrase on the recommendation of the council is to equip the government with the expert opinion of the expert constitutional body, that is the GST Council. This enables the government to take an informed decision based on such opinion of council. Since all the states have participation in the council, the recommendation of the council will certainly be in consonance with doctrine of cooperative federalism, unquote. My dear friends, adverting to the Supreme Court orders relaxing limitation, the court said that the directions were applicable to laws which stipulated limitation period, and section 73 was one such provision. After scrutinizing the direction passed, the court observed that it could not be said that the limitation extension were inapplicable in the present proceedings. My dear friends, it also observed that section 168A provides for time extension in respect of actions which could not be completed due to force majeure. My dear friends, I quote the exact words of the observation. My dear friends, in the manner statute, that is section 168A, is worded, there is no cavil of doubt that the lawmakers intended to give it a broader umbrella to bring within its shadow such actions which could not be completed or complied with due to force majeure. The COVID-19 pandemic created extraordinary difficulty which could not have been anticipated, measured and solved with mathematical precision. Thus, hair splitting in many aspects must be eschewed. While dealing with such an extraordinary crisis, the government's action must be viewed in broader perspective. It also relied on the Patna High Court decision in Mrs. Barhonia Engicon Private Limited versus State of Bihar, wherein it rejected a petition challenging notification extending the timeline for issuance of orders under Section 73 of the Act. My dear friends, in view of this, the High Court, while disposing of the present set of petition, observed, thus the question of validity of notification pales into insignificance, since the period between 15/3/2020 to 28/2/2022 stood excluded for the purpose of counting limitation by an order which became law of the land. The remaining argument relating to validity of notification became academic in nature. My dear friends, against this judgment, the present petitioner filed a special petition. During the hearing, the senior most advocate pointed out that there is a cleavage of opinion amongst different high courts of the country. The Supreme Court issued notice to respondents returnable shortly. My dear friends, this case is an important case to be watched. This case is a very important case to be observed by all the GST consultants, GST people, advocates who deal with GST and chartered accountants around the country. My dear friends, because Section 168 is such a powerful section, especially brought during the COVID period, whether the period of limitation will be applicable or not with respect to show cause notice is the question of law that is pending before the Supreme Court. Thank you, my dear friends.